3, 2, 1, start. In the inquiry report, there is no finding that the petitioner had caused loss to the boat and that as such the misconduct alleged against the petitioner in terms of Regulation 61E is based on no evidence. Stop para. The expression sufficiency of evidence postulates existence of some evidence which links the charged officer with the misconduct alleged against him, but the instant case no such nexus stands established. Stop para. So far as the contention of Mr. Mitro to the effect that though the factum of non-replacement of a defective meter was not incorporated in the charge sheet, the same was implied in the backdrop of the charges leveled. Stop. I find that the inquiry officer had not also considered the explanation given by the petitioner towards the alleged delay in replacement of the meter and the specific contention of the petitioner to the effect that there was a shortage of meters and the documents in support thereto as disclosed by the petitioner, were also not considered by the inquiry officer, and in the backdrop of such infirmities, the inquiry officer could not have arrived at a conclusion to the effect that the petitioner had delayed the replacement of meter by 16 months. Stop para. A perusal of the second so-cause notice and the order of punishment reveals that the alleged charges quoted in the same are different from the charges quoted in the charge sheet itself, and a comparison reveals that a charge to the effect that the petitioner, being a station in charge, had taken 16 months' time to replace his own meter had been specifically incorporated for the first time, and neither the second so-cause notice nor the final order reveals that the explanation given by the petitioner, fortified through appropriate documents, had been considered by the disciplinary authority, and such non-consideration tantamount to blatant the violation of the principles of natural justice. Stop para. The order of punishment contained in the memorandum dated 10th July, 2004 is absolutely cryptic, and having concurred with the findings of the inquiry officer, there is no explanation as to how, the disciplinary authority in the second so-cause notice proposed to the effect that the charges established against him warrants severe punishment through the alleged second charge incorporated in the said second so-cause notice was found not to have been proved. Stop para. According to the respondents, the charge of enjoyment of electricity with low consumption is attributable to the delayed replacement of the meter, but the said charge of low consumption itself had not been established by the respondents in course of the inquiry, as would be explicit from the inquiry report, and that as such the primary charge of enjoyment of electricity with low consumption having not been established, in my opinion the punishment imposed is unsustainable in law. Stop para. A comparison of the second so-cause notice and the final order of punishment would reflect that the contents of the same are absolutely identical, and in the latter there is only an additional line to the effect that the reply, dated 20th July, 2004 of the second so-cause notice of Sri Jagannath Adhikari has been received and carefully examined. Stop para. The disciplinary authority at the time of passing the final order should have considered the representations submitted by the petitioner to the second so-cause notice. Stop. Non-consideration of the same at the time of passing final order clearly establishes non-application of mind on the part of the disciplinary authority. Stop para. In the facts of the present case, the petitioner had specifically demonstrated the actual prejudice suffered by him due to the violation of the principles of natural justice on several occasions at the instance of the inquiry officer and the disciplinary authority which I had discussed herein above. Stop para. A perusal of the order passed by the appellate authority reveals that the said authority had misdirected itself by proceeding on the basis as follows: :para. 1. Petitioner effected a service connection in his name. 2. Petitioner took 16 months time to replace his stop and sticky meter. 3. Petitioner availed undue benefits of enjoying how low consumption by raising average bills during the period of stop para. Such findings at clauses 1 and 2 are absolutely unfounded inasmuch as the petitioner's service connection was effected in 1989 and he joined in stationing charge in 1994, and that as such the date of effect of the service connection has no nexus with the alleged delay of 16 months pertaining to a period in the year 2001. The finding at clause 3 had also not even been established by the respondents as would be explicit from the inquiry report. The words undue benefit had been incorporated for the first time in the appellate authority order. Para. In spite of the failure on the part of the respondents to establish and prove the charge of enjoyment of electricity with low consumption against the petitioner as reflected in the inquiry report, the disciplinary authority imposed a major penalty by modifying the charges at the juncture of issuance of second so-cause notice, and that too without considering the detailed reply to the second so-cause as a comparison of the second so-cause notice and the final order would reveal that the same are absolutely identical. 7. Expect inclusion of a line in the letter to the effect that the reply to the second so-cause notice had been examined. Most surprisingly, the appellate authority thereafter proceeded on the basis that the petitioner had availed undue benefit for the alleged delay towards replacement of the meter, though there was no whisper and no accusation in the entire proceeding to the effect that the petitioner had availed undue benefit for alleged delay towards replacement of the meter. From such sequence, it is explicit that the entire proceeding suffers from procedural irregularity, infirmities in the decision making process and perversity. It is well settled that in such circumstances, the court in exercise of the power of judicial review can interfere with the disciplinary proceedings. Para. The entire proceedings against the petitioner smacks of bias and closed mind. The inquiry authority, the disciplinary authority and the appellate authority had been swayed by a preconceived notion that the petitioner had delayed the replacement of the defective meter standing in his name. Furthermore, though the charge of enjoyment of electricity with low consumption could not be established by the respondents, the same had been taken into consideration by the disciplinary authority while imposing the punishment and by the appellate authority while affirming the said order of punishment. Such error in the decision making process warrants intervention of the Honorable Court in exercise of its power of judicial review. Para. In such circumstances, I quash the charge sheet, the inquiry report, the final order passed by the disciplinary authority and the order passed by the appellate authority, and as a matter of fact, the entire disciplinary proceedings initiated on the basis of aforesaid charge sheet dated 22nd April, 2003 against the petitioner. Para. The respondents are directed to grant the admissible service benefits to the petitioner which had been denied to the petitioner pursuant to the order of the punishment within a period of 8 weeks from the communication of this order. This writ application is, accordingly, is allowed.